Hello, everyone, and welcome to another edition of Employment Law Q&A. My name is Alex Lucifero. We are here this afternoon to answer any and all questions related to your employment, related to any medical leaves of absence or disability benefits issue that you have. Welcome to all of our viewers and listeners. If you're listening in, this is your opportunity. We're here now for the next half hour live on whatever platform you're watching or listening to this on to answer any and all questions related to your employment and any issues that you're having with respect to your employment. I am a partner and employment lawyer at Samfiru Tumarkin LLP. I've been practicing employment law and disability insurance law for quite some time. It is the bread and butter of our work. It's what we do all day, every day. We help people resolve their workplace problems. And again, that's what we're here to do live, free, on air for the next half an hour. So for those of you tuning in, maybe just tuning in right now, a couple of seconds late, please, if you're dealing with a situation at work, maybe your boss is mistreating you, you're not being treated fairly at work. Maybe it's even a colleague, not even necessarily a boss or a manager. Maybe there are changes happening at work. Maybe your employer has asked you to accept a different position, to accept a demotion or a change to your schedule. Or maybe you've been even demoted in your role, or you've been laid off temporarily from your employment. Any change at work can trigger your rights, your protections as an employee. If you're dealing with that kind of situation, please go ahead and post your question right now. You do not have to mention your name. You do not have to mention your employer's name. Keep it brief, keep it confidential, and just ask your question in a nondescript way, and I promise I will answer it in detail and I will get you moving on the way to resolving your workplace dispute. No one wants to be dealing with difficulties at work. It causes stress, not only in the workplace, but it causes stress at home. It causes sleeplessness, causes anxiety. You need to start alleviating that workplace stress. And the way in which you do that is to speak with an employment lawyer, get advice on what your options are, and what you can do about the particular situation that you're in. Certainly, if you've been let go from your job, and again, that can be a temporary layoff or it can be a permanent termination. Maybe you've been offered a severance package having been let go from your job. In that situation, before you make any decisions, before you sign on the dotted line on the employer's severance offer, please, I beg of you, speak to an employment lawyer as soon as possible. You could be leaving tens and tens, and I literally mean this, and we see it from time to time. You can be leaving tens of thousands of dollars on the table if you simply blindly accept an employer's severance offer without getting legal advice first. Oftentimes, employers will offer far less severance than what an employee is actually owed, almost expecting an employee to negotiate. But of course, if you don't negotiate, if you don't know what the way severance works or what the rules of the game are, you're none the wiser as to whether an employer's offer is reasonable or not. So please, any situations that you're dealing with at work, go ahead and post your question right now. I promise I will get to it before the end of the segment. And one last point in that respect. By the way, not only are you going to be helping yourself, very obviously, of course, in resolving your workplace problem, but do your other viewers and other employees out there a favor. I guarantee you, and we hear it all the time, and we are thanked by our viewers all the time. Listen, by asking your question, you are going to be helping dozens, if not hundreds, if not thousands, really, other employees out there that are dealing with a very similar problem and oftentimes the exact same problem within their workplace. So not only are you helping yourself, you're helping others out there as well by asking your question. A couple of pieces of contact information. You see it on the screen right now. Our website, please, if you want to learn more about a particular aspect of employment law, maybe you have severance concerns, maybe, again, there have been changes to your employment, visit our website, employmentlawyer.ca. Go ahead and post your or just visit the website. There are a ton of different links out there that deal with specific issues and even kind of the very basics of employment law. It's a great starting point if you're doing any kind of very basic research. Go ahead and visit our website. Of course, our website also has all of our contact information as well. So you can find individual lawyers, you can find their general line, don't be shy to give us a call, by the way. We have an entire intake team standing by to answer calls and questions. You can also email us, by the way, and do not be shy to email us. There is no charge whatsoever. The email address is on the screen right now, and it is very simply help@employmentlawyer.ca. Help@employmentlawyer.ca. Send us an email. Give us a brief description of the situation you're dealing with. Do yourself and do us a favor. Don't send us a 10-page email. Right? Give us a general description and a brief description of your situation. If you're let go, maybe give us the basics around the situation. I guarantee you someone will contact you back if you email us with a question or an issue that you'd like to discuss. So go ahead and email us there. All right, might be time to get to the questions, but I wanted to chat about a little matter first before we get into them. Once again, for those of you just tuning in, my name is Alex Lucifero. I'm an employment lawyer, partner with Samfiru Tumarkin, LLP. We are the employment lawyers in Canada, in the provinces of Ontario, British Columbia, and Alberta. If you're in one of those provinces, in one of those jurisdictions, and you've got a question for us, you're dealing with an issue, not sure how to handle a situation at work, maybe you've been passed up for a promotion and you have some concerns. Maybe your boss, again, you get the feeling that maybe your boss wants you out of your position or wants you out of the company potentially. Again, don't be shy. Post a question right now. This is a live Q&A. And I promise before the half hour is up, we will get to your question. Very quickly, only because this has been in the news very recently, I made a note actually to talk about it today. It's not a massively common issue, but it's a nice little reminder of the rules around workplace relationships and romantic relationships in particular. You all might have seen over the course of the past week, there was actually a pretty interesting, but unfortunate for these employees, quite a difficult story coming out of the Royal Bank of Canada, so RBC. Two relatively senior employees, quite senior actually, employees within that company were let go because they had a romantic relationship and were both employees of the company. And after the employer conducted an investigation into the matter, they uncovered that one of those two employees received promotions and effectively was being treated differently, was given advantages that otherwise wouldn't be available to that employee, because of course, the romantic relationship. Quite obviously, to I think most of you, and certainly myself as an employment lawyer, both of those employees were let go from their jobs. And I wanted to mention this because, again, it doesn't happen often, but for any of you tuning in, if you're dealing with a romantic relationship at work, point number one here is that you have to make sure that there is absolutely no favoritism being shown, that there is absolutely no bad faith being shown to other employees. You also want to make sure if your employer has a romantic relationship workplace policy, that you review that policy and you understand very, very well what your rights and obligations are as an employee who's dealing with a romantic relationship within the workplace. Listen, I'm not saying here, I want to be clear, romantic relationships in the workplace are not illegal. And actually, I think an employer that institutes a policy that says romantic relationships are banned in the workplace, I actually think that's a pretty darn silly policy. I don't think it makes sense for an employer to outright ban romantic relationships in the workplace. I mean, on one, it's just not practical. If your workplace is large enough, it's going to happen whether you ban it outright or not. You can only stop human nature to a degree. But what you want to do instead as an employer is make sure that the rules around these romantic relationships are very clear and very obvious. As a starting point, you as an employee may be required to disclose the romantic relationship. So you actually have to let your employer know, hey, by the way, I have a relationship with this person, right? And any potential conflicts that arise out of that relationship, for example, if it's between a manager and an employee of that manager, that is a problem. That power dynamic between a manager and an employee in a romantic relationship can cause real problems at work that an employer should be avoiding. And so a solution needs to be found there. You cannot continue that situation as an employer. You're going to need to make arrangements to perhaps move that employee to another department, or somehow make arrangements. And it's possible that those, that someone's employment can't continue. So a reminder to all of you out there, if you're dealing with a romantic relationship within the workplace, as was the case at the RBC, and again, for relatively senior employees, make sure that it's not being kept in kind of complete confidence, because you may have an obligation legally to report the relationship to your employer. And B, you want to avoid any kind of hint, and I mean absolutely any kind of even hint of a conflict of interest within the workplace. Right? And that happens particularly when you're dealing with a romantic relationship between a manager and an employee of that manager. And that could be a director and a manager, or a VP, or a CEO, whoever it might be. Those are extremely dangerous situations that, listen, if I've got my employer hat on, speaking to any employers that are tuning in, you want to avoid those kinds of situations at all costs. And again, banning workplace relationships isn't the easy solution that you think it is. It doesn't solve the problem. So with that in mind, let us get to the questions, ladies and gentlemen. Again, very quickly, for those of you just tuning in, my name is Alex Lucifero, employment lawyer, partner with Samfiru Tumarkin, LLP. We are the employment lawyers, and we are here today for a live Q&A, as we do regularly throughout the week. It's your opportunity to ask us any questions that you have related to employment law, related to your workplace rights, any particular issues you're having at work. Please go ahead and post your question right now, because it's Q&A time. Best part of the segment, in my opinion. I get to answer all of your questions, and you always ask excellent questions. By the way, if you're dealing with a medical leave, if you're dealing with disability insurance, if you're having difficulties at work with your employer accommodating any medical restrictions you might have, please, that's an employment issue as well. That's a disability insurance issue potentially as well. Go ahead and post your question in that respect. Do not be shy. Those are oftentimes the most important of questions, because employees have significant rights when it comes to medical leaves of absence, disability insurance, accommodation in the workplace when it comes to medical restrictions. Go ahead and ask your questions related to a medical leave or disability. By all means, I would be more than happy to help in any way I can. All right, first in line for today is Dominic. Dominic, thank you so much for asking your question. Dominic says, hi, love your show and advice. Long tenured employee here, almost 20 years in finance. Employers demanding a change to my job duties. I have a disability too. Can they do this? Dominic, excellent question. Question we field every day, all day, effectively. The question is, can an employer make a change to your job responsibilities or job duties or job description, whatever you want to call it? Dominic, the answer is going to depend on the degree of change. So this is where we get into the nitty gritty of, your job duties and how much of your job duties are really changing, Dominic. And the general answer is this. Do keep in mind, and for all of you out there, not just Dominic, listen, nobody's job is set in stone forever. An employer is allowed to make changes to your job responsibilities or your job description, and maybe even your schedule, to a degree, right? Again, there has to be some degree of flexibility there. Nobody's job is ever written in stone permanently and stays exactly the same over the course of many years, even the 20 years that Dominic's worked in finance, right? So a degree of change is going to be allowed, Dominic, but if the change is major, and the language that the law uses is if the change is substantial or significant, and that might be in the eye of the beholder, by the way. But if we're talking about a major change to your job duties, Dominic, then the answer to your question is no, they're not necessarily allowed to do this. And I would say even more so that would be the case if it's going to impact your health, your disability. If you need accommodations in that respect, your employer may not be able to change your job responsibilities really at all as a form of accommodation. So listen, the short answer to the question, Dominic, is what is the degree of change that your employer is proposing? If the degree of change is relatively minor and insignificant, well, then they could probably do it, and do it even without you particularly being crazy about it. If the change is going to be a significant one, And particularly if the significant change is going to start impacting your health and your disability and your ability to work, right? If you're being accommodated, then the answer will be outright no. Your employer is not allowed to make those kinds of changes. You have the right to say, no, thank you. I am not agreeing to this change. If your employer presses you on it, Dominic, if they say, well, then too bad, we don't care if you like it or not, Dominic, we're making this change regardless. I don't care whether you say yes or no. It's not up for debate or agreement. You may be in what we call a constructive dismissal situation. A constructive dismissal is when an employer imposes a substantial change on the employee. That would then allow you to effectively resign, Dominic, to quit your employment and then still obtain your severance entitlements. That is what a constructive dismissal gives you. It's basically like a breach of contract where you can consider the relationship at an end and you can pursue your severance. And by the way, Dominic, based on 20 years of service, your severance entitlements are going to be significant. They're probably going to be in the range of anywhere between 18 and 24 months of pay, not, not weeks, months of pay, to be clear. I did say months. So your severance could be a hefty amount here. Dominic, before you quit, before you send an email to your employer taking the position that you've been constructively dismissed, please do yourself a favor, do us a favor, send us an email, reach out to us at help@employmentlawyer.ca, or give us a call at the office. I'm always more than happy for people to pick up the phone and call us. Let's have a chat. Let's figure out exactly what changes your employer is suggesting, exactly what your situation is, exactly what kind of medical issues you're dealing with. I guarantee you we will be able to come up with a plan, right, that addresses all of your rights in the situation, all of your obligations, and puts you on the path to doing the right thing and the best thing for your circumstances. Great first question. Thank you so much for reaching out, Dominic. Next up in line, I believe on YouTube, is a question from Muzmoya. If you are working as a contract employee and are let go before the end of your contract, are you owed severance? Excellent question, Muzmoya. And the short answer is yes. Even as a contract employee, if you are let go in the middle of that contract, the default setting, so to speak, in terms of the way the law works, is that you are going to, your employer or the company, right, if you're a contract employee, didn't hold up its end of the bargain. And as a result, you are owed the balance of the contract. So, for example, if you sign a 1-year contract with an employer, right, and you're effectively guaranteed work for 1 year, and 6 months into that contract, the employer says, you know what, we don't need you anymore. This is not working out. We're letting you go. You would be owed the balance of the contract. So in that example, the 6-month balance, as effectively your severance entitlements. Now, there is one thing to keep an eye out for here that might be very important in these circumstances, and that is any contract that you would have signed with the company or with the employer. Oftentimes, and particularly nowadays, there will be language in a contract that spells out what kind of notice or what kind of severance an employee might be owed, even if they're a contract employee. So there might be language in your contract, Muzmoya, that says, if we let you go during the contract term, we owe you 30 days notice, or your minimum severance entitlements under the Employment Standards Act. There'll be some sort of language potentially there that speaks to what you might be owed in the event that they terminate your contract. And if that language is enforceable, if it's legal, then you might be held to the terms of that contract. So the contract is an important thing to review. I will tell you this as a last point on this particular subject, and this is what we say about severance more generally, and it continues to be true to this very day. I have seen many contracts, including contracts as recent as 2023 or even 2024. We're talking state-of-the-art recent employment contracts, and even contracts with a fixed term, with a specific start and end date. I have seen employers propose those contracts and have employees sign those contracts with termination language in them. And the termination language in those contracts is not enforceable. Termination language in an employment contract needs to be very carefully worded, very carefully written by an employer, and the use of even one wrong word or one wrong phrase can render the entire termination paragraph or the entire termination provision completely unenforceable. So, Muzmoye, even if you do have a contract, right, that says the company might be allowed to let you go within the contract period, and maybe it says 30 days, or maybe it says some other formula for calculating what your severance entitlements are, don't just assume that the termination language in your contract is enforceable. Make sure before you just walk away from the contract, make sure before you accept any kind of severance offer from the employer, make sure that you speak with an employment lawyer to figure out whether the termination language in your contract is enforceable or not. As I just said, more often than not, the language that we see in employment contracts is actually not enforceable, because the law is very, very particular, very meticulous about what that language should look like. And again, even a small mistake on the part of the employer will render that contract completely unenforceable, which means you would be owed the balance of the contract, or you would be owed your full severance entitlements. Another great question. Thanks so much. Another question from Noverton. Noverton on YouTube, I believe, asks, I was off on sick leave when a new company took over. I was offered a full-time position, but was terminated shortly thereafter. I worked with the original company for 13 years, but was only offered 8 weeks. They didn't know I was on sick leave when they made the offer. What are my rights? Noverton, great question. And I think you're on the right track here, at least with respect to your medical leave of absence. What I mean by that is, listen, an employee who is on medical leave of absence, as odd as this might sound to a lot of you, an employee who's on a medical leave can still be let go from their job. Nobody's guaranteed their job, even when they're on a medical leave of absence. Their employment could still be terminated if the reason for termination is very obviously not related to their medical leave or not related to their health issue. So, you mentioned the context of a new company taking over, Noverton. Listen, maybe that means that your department was restructured or your position was eliminated. In other words, if the reason for your termination had nothing to do with your leave of absence, with your sick leave, then the employer would be allowed to let you go. This is not a discrimination case. And I'll give you the opposite example. If you were let go, even if just a small part of the reason for letting you go was related to your sick leave, right, that would be discrimination under the Human Rights Code in Ontario. And you would not only be, of course, owed severance, and we'll get to severance in a sec, by the way, you would also be owed additional compensation for the manner of your termination, for the reason of your termination being based on discrimination, being based on your sick leave. So question number one is, was the termination tied to your sick leave or not? If not, it's strictly a matter of severance. Noverton, if somehow you feel as though, or you genuinely believe that your sick leave did have to do with the termination, well, now we have to explore both severance and discrimination, or additional compensation for your termination. Now, to get to severance, Noverton, and for those of you that are contemplating severance, maybe you've been let go, maybe you're worried about being let go, a couple of points here. Number one, if you want to know what your severance entitlements are, visit our website, pocketemploymentlawyer.ca. It will give you a pretty good assessment of what your severance entitlements are based on your age, position, and years of service. This is strictly confidential, by the way. You don't have to insert your name. You don't have to put your employer's name. Just give us your age, your approximate position, whether it's management or labor or administrative, or maybe a supervisor or a technical position. Give us your position and your length of employment. And with those three factors, because by the way, those are the three factors that are relevant in assessing an employee's severance entitlements, out will come a number, or a range of numbers at least, giving you a rough sense of what your severance entitlements are. If you have 13 years of service with the company and with the original company, Noverton, and obviously carrying over to this employer, listen, I don't know your age, I don't know your position. You can pop in quickly into the chat here what those are, and I'll be able to assess it more easily. But I could tell you, with 13 years of service, Noverton, you're probably looking at least a year as your severance entitlements. So right there, if you've been offered 8 weeks of pay, That is well short of what your severance entitlements are. And I also have to say, and I hate to say this, I say it begrudgingly, but I'm not surprised by that number. 8 weeks are likely your minimum entitlements under the Employment Standards Act if you're in Ontario. And so basically what the employer's done here in Overton is they just offered you the bare minimum, and they're expecting and waiting for you to bounce back and counter offer and negotiate from there. My advice in Overton, don't respond to the employer right away. Give us a call first, right? Email us at help@employmentlawyer.ca, or visit our website, employmentlawyer.ca, or again, just give us a call and speak with an employment lawyer. Make sure you're being treated fairly. It sounds like you have some improvement to be made to your severance entitlements. All right, next up in line, we'll do a couple of these rapid fire, guys, only because we're starting to run out of time. Next up in line is Chris. Chris on Facebook asks, when you have multiple people going to HR regarding a bullying supervisor and the management refuses to address these issues, what can you do? Chris, great question. And it's a great question only because we hear from people, really every day. And I don't say that as an exaggeration. We hear from people every single day that are dealing with a difficult colleague or manager or supervisor in the workplace. And listen, I think we can all understand that some people can sometimes be in a bad mood. Not everybody's going to be bright and positive and chirpy, and overly friendly. But when we're talking about harassment or when we're talking about bullying, oftentimes people have a very clear idea of what that looks like. It oftentimes looks like yelling at others. Oftentimes it looks like speaking down to others. Oftentimes it looks like embarrassing employees in front of their other colleagues and during a meeting with multiple people there. It can obviously get a heck of a lot worse than that. But those are just a couple of the common and quite frequent examples that we see of what would constitute harassment and bullying in the workplace. So, Chris, if that's a situation that you and your colleagues at work are dealing with, the specific concern that Chris had was, listen, if all of these raising these concerns is falling on deaf ears, if management just simply isn't responding to a number of employees complaining about a supervisor who is being a bully, who is harassing other employees in the workplace, what do you do in that situation? You've gone to management, you've gone to HR, right? If you've done what you have to do in that respect, what are the next steps? Chris, if you're dealing with a relatively serious situation, as I just said, again, when you're being yelled at or being sworn at or being spoken down to, or if it's even worse than that, and it could be worse than that, listen, that's when an employment lawyer gets involved. And we have a couple of tools in our tool belt, by the way, that we can use here. Either as an employment lawyer, I would recommend claiming constructive dismissal, meaning an employer refusing to do anything about harassment or bullying in the workplace can be viewed, and sometimes should be viewed, as a breach of contract. The employer has an obligation, Chris, to protect you from these kinds of situations, to make sure that the workplace is safe and a positive environment. If they're not holding up their end of the bargain, you might be able to treat your employment as at an end, get your severance entitlements, and get moving on to new employment. That's option number one. Don't do that without speaking with me first, Chris, or without speaking with one of our lawyers at least first. Second option is you may want to file a complaint with the Ministry of Labor. If you're in Ontario, Chris, that might be another option that you can use. Let's say you want to keep your job, right? Let's say you don't want to claim severance, you don't want to pursue constructive dismissal. You can file a complaint with the Ministry of Labor. It would be under a piece of legislation called the Occupational Health and Safety Act, right? And force the company to react and force the Ministry of Labor to investigate. So those are the two options you have. Chris, before you choose one of those options, give us a call. Let's have a chat. More than happy to do so myself if need be. All right, very quickly, let's do this in 60 seconds, everyone. Delia asks, if you are put on working notice and the employer offers a different job that you're not accustomed to, can they argue that if you don't accept it, they don't have to pay severance? Is this legal? Excellent question, Delia. The answer is how comparable the position is or isn't. So listen, I understand that it's a job you're not accustomed to, but is it something that you can do that's within your skill set, that's within your ability to learn? Does it have the same pay? Is it on the same schedule? Is it kind of roughly equivalent, right? I get that maybe the actual ins and outs of the day-to-day job might be somewhat different, and maybe you're just not used to it. But is it something that, if you're looking at it objectively, is it more or less on par? Would it be considered kind of a parallel move? If it's a parallel move, Delia, I hate to say it, but it may impact your ability to ask for severance, because your employer is basically offering you to continue working, right? And that kind of ends the severance conversation if your employment's going to continue. So, the answer is in the details of how comparable the position is or isn't. I'm sorry I didn't get to all of your questions. Unfortunately, there's a couple that I left unanswered. I hate to do that, but time is up, unfortunately. Good news for those of you that haven't had your questions answered. We've got another live stream tomorrow with my colleague and excellent employment lawyer, Dan Balkaran. Please tune in. Go ahead and post your question there. And I promise Dan will be more than capable and more than happy to answer it. Thank you all so much for tuning in. It's been another great live Q&A. Excellent questions. I hope I've gotten you on your way to resolving your workplace issues. Until next time, everyone, have yourselves a great rest of the day and a great rest of the week. And until next time, take care.